So you've got a series of trustees, and sorting out their powers is a tricky matter, and it is a complex matter. The powers of the trustee of an SPV pool are set forth in the prospectus and the indenture to the mortgage-backed bond. And you'll usually find that while it has general powers for the trustee at the beginning, as you read on, buried deep within the document, they're not allowed to go ahead and enforce any mortgage note obligation or get involved in any litigation without express permission of the investor who owns the actual notes and mortgages and obligations. So on page 2, and we'll end up with analyzing just page 2 in this segment, you can see on your screen that the document contains some very interesting conflicting wording. This document is not sufficient for you to say that you have won and the other side has lost, but it is sufficient to utilize the strategies that I have recommended, and that is to raise questions that are of sufficient credibility as to require the pretender lender who is initiating foreclosure to answer discovery requests, to compel them to answer qualified written requests, and to compel them to answer debt validation letters. And it's right here that many of the pretender lenders drop off the face of the earth, because they're looking for the low-hanging fruit, not people who understand securitization and want to peek at what happened in the chain of securitization on your loan. Look at this wording where it says, concurrently with the execution and delivery hereof, RFC hereby assigns to the company without recourse all its right, title, and interest in and to the mortgage loans, including all interest and principal received on or with respect to the mortgage loans after, and there's a special term in there, the cutoff date, other than payments of principal and interest due on the mortgage loans in the month of the cutoff date. And then take a look at these numbers. In consideration of such assignment, an amount equal to $476 million is going to be paid, including accrued interest and the retained certificates. The retained certificates are, in most cases, the certificates that should have been given to the investors and weren't, which is why homeowners have a shared interest with investors in pursuing all the intermediaries in the securitization chain, because both the investors and the so-called borrowers were cheated in the same way. They were sold a financial instrument, a financial product, under false pretenses, and the false pretense in both cases was inflated value and inflated quality. For the investor, it was inflated value of the bond, which obviously most of the mortgage-backed bonds are trading at very low rates, 1 cent on the dollar, etc. And the quality that they thought that they were buying, or they say they thought they were buying, came from the AAA ratings from from Fitch, Moody's, Standard and Poor's, and so forth. On the other side, the borrower was given the same story. He was given an appraisal, which is the same as a rating, and that appraisal told him that this deal was worth more than it really was. And he was given the impression that the mortgage originator went through an underwriting process, which is common to the industry, where the appraisal is verified. So both the borrower and the investor, who were the only real parties to this transaction, were deceived in the same way. And when you look further down the page here on page 2, you will see there is substantial wording there that indicates that the parties intend to transfer ownership or the mortgage or to perfect the security interest and so forth for some purposes, but not for others. So right in the assignment and assumption agreement, there is a conflict not only with itself, but with state law regarding recording and perfecting liens. So what is the point of looking at an assignment and assumption agreement? The point is not to argue the assignment and assumption agreement to the judge and say, Judge, my client should win and get a free house right here and right now because of my brilliant legal argument here today. That kind of argument will get you a very skeptical judge who probably is not going to hear another word you say. The point of this is to raise issues wherein you can say to the judge, we've got legitimate questions that we want answered. Maybe we got claims, maybe we don't. But they're supposed to, under the Truth in Lending Act and the Real Estate Settlement and Procedures Act, they're supposed to give us information about who the true lender is and what the full accounting is of all the transactions that were involved in this loan. And we need to know dates, we need to know who signed, we need to know witnesses, we need to know notarization, we need to be able to confirm that the documents that they say they're relying on exist and weren't fabricated or forged, and that this is not another one of those cases which we will cite to the court, like HSBC versus Valentin and other cases in Kansas and Florida and other states, where fabrication of documents, fraud in the presentation of them to the court, and forgery of the signatures was the rule rather than the exception.